Donald Trump created the smoking gun evidence against himself and his own DOJ that resulted in subpoenas being quashed when he tried to weaponize the DOJ and abuse the grand jury process to go after the government officials in Minnesota. Here's what went down. It was actually a George W. Bush appointee, Judge Schiltz, a federal judge in Minnesota, who quashed the subpoenas that Trump's DOJ was issuing at the Minnesota top government officials, Governor Walz and others. And what the federal judge cited was Donald Trump's social media posts and Donald Trump's behavior and Donald Trump's statements saying, essentially, I want retribution against Minnesota unless and until the governor allows me to invade the state of Minnesota. I'm going to retaliate against them by launching a criminal investigation. And the federal judge said under the 10th Amendment, when we talk about states' rights, the federal government can't abuse grand jury process to do what's called commandeering of the state's rights and to force the state's rights into submission by threatening criminal prosecution. Let's take a look at the court's order. Let's go through it as we like to do here on the MeidasTouch network. And so you had the Minnesota government filed a motion to quash, and they argue that the motion that these grand jury subpoenas that were sent as part of a criminal investigation that was making all of these, frivolous allegations that the government in Minnesota and the governor and the attorney general were working with Antifa to try to overthrow the federal government, and they were fomenting insurrections against ICE and Border Patrol. Hey, let's take a look at what this order said from this George W. Bush judge. The moving parties, Minnesota, argues that the subpoena should be quashed for a number of reasons. The court need to address only one of those reasons. The moving party's contention that the subpoenas were issued as part of an unconstitutional effort to coerce Minnesota officials into assisting the federal government with enforcing civil immigration laws and to harass and retaliate against them for failing to do so. The court agrees with the parties, agrees with Minnesota, the moving parties. Under the 10th Amendment anti-commandeering rule, the federal government may not command the state's officers or those of their political subdivisions to administer or enforce federal regulatory programs. It goes on to say, nor may the federal government coerce or retaliate against states or political subdivisions who decline to help the federal government enforce federal laws. This is as true in the context of immigration enforcement as it is in the context of federal regulatory programs. Initiating a criminal investigation to harass political opponents or to coerce them into taking official action, particularly official action that the federal government cannot directly require those political opponents to take, is a blatantly unlawful and unethical use of the grand jury process. So then the federal judge said, let me show you the evidence that I have. Well, it's a high burden to quash grand jury subpoenas because there's a lot of flexibility when the DOJ seeks to have the grand jury issue subpoenas. Any presumption or presumption of regularity that we feel towards the DOJ, that's out the window. First, the federal judge says the public record, as recited above, is replete with direct evidence of the Trump administration, including at the highest ranking officials at the department, threatening and attempting to punish states and localities that have adopted, quote, sanctuary policies, as well as attempting to coerce those states and localities to devote resources to assist federal immigration enforcement. Just to cite some of the highlights. One, Trump repeatedly directed the withholding of federal funding from sanctuary jurisdictions, sued Minnesota and its political subdivisions to invalidate their sanctuary policies, and unleashed vitriolic tirades against Minnesota officials for not assisting the federal government in enforcing immigration laws. Two, the day after Minnesota, Minneapolis, and St. Paul filed a lawsuit challenging Operation Metro Surge, Trump posted a message on social media criticizing Minnesota's failure to cooperate with ICE and promising the, quote, great people in Minnesota that the day of reckoning and retribution is coming. Again, Trump explicitly threatened retribution against Minnesota's political leaders for exercising their constitutional rights. 3 days after Trump threatened retribution. Someone leaked the existence of the grand jury subpoenas directed to Governor Walz and Mayor Fry's office. Then it goes on to quote all of Donald Trump's other speeches. And then as a result of the totality of these circumstances, then it goes through what was requested in the subpoena. And it's like all of the communications you've ever had, Governor Walz, Fry, the state attorney general, the federal judge quashed these subpoenas and says Trump's Exhibit A in the unconstitutional approach by Trump's DOJ. Let's bring in Harry Litman from the Talking Feds YouTube channel, Substack, and podcast. Harry, kind of a theme that we've been showing, I guess on the positive side of this, Trump has created the evidence that allowed this to be quashed and to be exposed. But I guess the frightening proposition is that had he not been boasting and bragging about the unconstitutional behavior, the way the Trump regime has behaved about grand jury secret proceedings, we may not have known all of this stuff. I mean, all of these cases involving grand jury secrecy now being pierced, fortunately, is because Trump and Bondi and Blanche have basically bragged about it. So it's rebutted presumptions of regularity and secrecy. And here, Trump's words rebutted a lot of those presumptions that it's very hard to quash a grand jury subpoena, as you know, in a situation. But we're seeing this with a degree of frequency, and Trump's creating the evidence against himself. What do you make of it, Harry?
Yeah. First, we would have known this is the judge, Ben, if you may remember, that he's the chief judge of the District of Minnesota who already said famously, you guys in ICE have violated more orders, I think it was in January, a single month, than most agencies have in their lifetime. So the presumption of regularity is very much out the window with this guy. But it's also more than that, because what they were seeking, and there's an accompanying saber-rattling letter from Pam Bondi accusing with no basis the state of impeding the federal law enforcement. I'll get back to that in a moment, but saying, therefore, we would like all your records of everything having to do with immigration enforcement back to January 2025. This is sent in 2026, a year behind, but that's the least of it. Also, we would like you to stop having your sanctuary policies. And also, we want all your voter roll information. So that is really transparent what they're trying to do and leveraging any port in a storm to try to get at the voter rolls. And Schultz says the asserted reason for these subpoenas by the government is risible, is completely a joke. And I don't know if he'd have written that a year ago, but he has seen some other bad jokes from the Department of Justice. But now let's go to the other point, because it's big to me. I've been waiting for a judge to do it. And to my knowledge, Ben, he's the first. There is this really important anti-commandeering principle that the conservative Supreme Court has really hammered home. The states or anybody can't get in the way of, literally impede or obstruct federal law enforcement, but you cannot force them to lift their little finger to help federal law enforcement. The big case in the area is you can't make them get information, just ask information about from somebody applying for a gun about whether they've had criminal penalties. That's commandeering in this very kind of liberal sense of commandeering, making the states do anything. And there are all kinds of ways in which basically the DOJ is saying you're impeding with federal law enforcement, and the state ought to be coming back and saying, hey, we're not impeding at all. What we're not doing is helping you. What we're not doing is abandoning our legitimate state policies and laws, for instance, sanctuary status. If you can get us actually impeding, come ahead. Although we've seen again and again and again, ICE and others make that charge, and then they wind up dismissing because it's really been they who have been going after First Amendment protected activity. But if other courts become similarly sensitive to this principle, the place where the federal government's zeal and desire to get the states to help them out ends at the very border where they're asking the state to do anything affirmative. That's what's happening. You know, give us your voter rolls. That's something affirmative, more extensive than things the court has said doesn't work. So two things going on here. One, complete risible, as the judge says, to try to be using this in a patent attempt to, come on, get at voter rolls, get at sanctuary. They're totally full of it. But then second, and more broadly applicable perhaps, this anti-commandeering principle. Feds, you may not push around the states even in the slightest way. And as state attorneys general come into the fore, especially in the absence of, vigorous action by other folks or difficulty of bringing standing arguments, that sort of argument could be very powerful, because so often you're looking for the states to help you out. And this says very stark terms, you may not require the states to help you in any way.
Everybody, make sure you subscribe to Harry Litman's YouTube channel. It's called Talking Fed. Subscribe to his podcast and Substack as well. Also, Harry, why don't you briefly mention your July 3rd event with Senator Schiff as well?
Okay, so July 3rd, 10:30 in La Jolla. We do these one-on-one live conversations, and we're doing one with Senator Adam Schiff. It should be really great. You can just go to talkingsandiego.net, get all the info and tickets if you like.
And everybody subscribe to our YouTube channel, subscribe to Talking Feds, and hopefully we see you at the July 3rd event in La Jolla. Thanks, everybody, and we'll see you next time.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.